Three, two, one.
This Honorable Court of Appeals is now in session.
Good afternoon and welcome to the Court of Appeals. We first of all want to thank you and your clients for agreeing to participate in this oral argument via Zoom. It is the best way for us to continue to do our work, I believe, under the current state of affairs. Both of you are experienced practitioners and understand the process here, and we will be operating as if we were in the courtroom today, which essentially means that each side gets 15 minutes to make its oral argument. If you're the appellant and you've reserved rebuttal time previously with the clerk, you'll also receive that rebuttal time. Before we get started, I want to introduce the panel for this afternoon. We have Judge Thomas Skip Frierson from Morristown, Judge Karma McGee from Savannah, and I'm Steve Stafford from Dyersburg. Miss Angie, anything we need to take up before we get started?
No, Your Honor.
All right, you may call the case, please.
Diversified Financial Services, LLC versus Jeffrey Wayne Daniels.
And we shall hear from the appellant.
Good morning, Your Honors, and may it please the court. Is my audio coming through okay?
It is.
Okay, thank you, Your Honor. This may be the rare case where I don't use the entire argument time, but unless, of course, the court has questions for me, which, of course, I'll do my best to respond to. Jeffrey Daniels is the victim of a wire fraud scheme that was perpetuated by Charles Schindler over the course of approximately 9 to 10 months. Charles Schindler is now a convicted felon in the penitentiary in Texas, where he owes a $4.3 million restitution order. Your Honor, this case was part and parcel of that scandal. And I hate to oversimplify something that is the court's job to honor, each and every aspect of law that it is confronted with. Nevertheless, I do believe it's possible. I still believe that it is possible under certain circumstances for the court to have a matter where it can take judicial notice of sufficient facts to make a determination on something that is a matter of inception, something from which the court does not stand, from which all other matters proceed in this lawyer's humble opinion. So, Your Honor, my argument is simple. The defense counsel or plaintiff's counsel, actually the appellee, that they do admit to the fact that Mr. Daniels did not receive his equipment, okay, an expensive piece of farm equipment, a Hardy sprayer. That is, as if you were leasing a car, no different. You're leasing a piece of farm equipment. There's no dispute that equipment was never received. It wasn't he had it a week. It wasn't, some circumstance. It wasn't that he was delivered the wrong equipment. And we have that circumstance in other cases that are part of this scandal. And it's a much trickier issue. This is the exception where this is the situation where nothing was delivered. There wasn't any temporary possession and nothing like that. There's no issue of the form of the consideration. So what we had, there's no issue that there's no dispute that as to whether or not Mr. Daniels received any money. So call it consideration, call it benefit of the bargain. But so in my opinion, Your Honors, that issue is so material, so substantive, and it's just such a threshold matter that it is possible in this case for the court to examine that, to focus on that. And I will talk about the procedure. Counsel opposite would argue would argue just for a very hard line, strict interpretation of what may constitute consideration. And that his argument, the bank's argument is very simply, they relied on a contract, they relied on a document. I can't call it a contract because it requires legal validity to use that term, but they relied on a document, a signature, and they transferred money to a criminal. That criminal stole that money. No dispute. That equipment was never delivered. Your Honor, we have, I'll just say this in passing because I think it's relevant, that equipment, the equipment never existed. We think we can prove that, but that's really a side point. Be that as it may, that's the circumstance before this court. So I think that it, you say it's too illusory. You say there's consideration to the extent that money was transferred to that. They want to call Charles Schindler, Mr. Daniels' supplier. That's a misnomer. I think the court needs to be aware that he was an equipment broker for a long period of time, for approximately 10 years. He's a man that the banks trusted. He's a man that got into a divorce, got into some bad business, and came up with this con scheme, and through for a lot of reasons, through the bank looking the other way, for a lot of reasons, he was able to pull off this major scandal. So the only question to the court, and I will talk about the procedural aspects, is if a criminal receives money, steals that money, delivers no, what we call just, real actual consideration. There's no money, no equipment. Can that nevertheless form a legal contract from which this court takes, proceeds, or from which the trial court proceeded? And I would say that that's illusory. That's ephemeral. That doesn't have any objective, tangible quality in real life that any member of the public can understand, that any member of the public can have any comprehension of for the purposes of ordering this society. And that it's a miserably arcane concept for me to have to explain to my clients who are victims, who are being, in this lawyer's humble opinion, who are just being taken advantage of in a very bad situation. Now, the bank would say they're a victim too. That's another matter. But so, Your Honors, I will segue to my brief point on the procedural, or the point that I do want to make on the procedural aspect of this case, because it goes to a deficiency of evidence in the trial court record. Mr. Daniels was available to testify and provide evidence on the circumstances surrounding this transaction. And Your Honor, this was back when we're more accustomed to doing things by Zoom now. Coming through the pandemic, this was kind of in the early days of that. We were still becoming familiar with that process, and there's been some delays in this case. I mean, everybody is in a new world. All of that was happening in the midst of this. I will say that briefly, but on that procedural point, Your Honor, that the court did not. Mr. Daniels was on the phone. He was able to provide testimony of this. What I consider to be just as threshold of an issue as this court can consider, as much of an issue of judicial notice as is possible. Okay, and those things do exist. We're trying to do justice. It kind of, to some extent, it kind of puts our art form it lays it aside, under some circumstances, and we lawyers don't like that sometimes. Okay, but I do believe that circumstance still exists. But for the failure of the court to consider that testimony, there would have been sufficient factual information in the record for this court to have ruled in the appellant's favor I fear that this court will say that we don't have the record to make the determination. But again, in this humble lawyer's opinion, when under these circumstances, there's enough for the court to say at minimally, I mean, we would like to have it, full relief, but I think minimally to say that the trial court needs to make sufficient findings of fact on that narrow issue, on that very narrow issue, that would be a real limited, undertaking, so that the judgment can be more properly examined and by remand. And I'll reserve any time that I have, Your Honors, if the court doesn't have any questions for me.
We'll hear from the appellee.
Thank you, Your Honor. Please, the court. I'm Gregory C. Loeb with the Wolf McLean firm in Knoxville. I represent Diversified Financial Services in this appeal. I would first say the manner in which this case has been defended and the manner in which it has been handled on appeal or prosecuted on appeal by the appellant makes it difficult to respond. I've set forth the procedural and material facts in my brief, and I will not go into a lot of detail on that. However, I'd like to make three important points today in response to the appellant's argument. First, the appellant's brief is so devoid of merit and so procedurally deficient that the appeal should be dismissed. In the oral argument you just heard, you did not hear one citation to the record. You also heard talking about testifying at a hearing. This case was decided on a summary judgment motion. Again, I find it difficult to respond to a case that is so devoid of merit. This case had numerous delays in the state court, and the delays in this court are well documented. Numerous extensions were given to the plaintiff, the appellant defendant in this case, to file a brief. What the appellant filed was a 2-page brief, and it's devoid of any citation to the record. This brief fails in part Rule 24, Rule 27, Rule 29, Rule 30, but most importantly, Rule 27, which in part in Section 7, Rule 27, the appellate rules, makes it very clear that the contentions of the appellant with respect to the issues presented and the reasons therefore, including the reasons why the contentions require appellate brief with citation to authorities and appropriate references to the record. Everything that Mr. Lofton told you about in his argument is not in the record. More importantly, he makes a totally false statement that somehow my client admitted that there was no equipment. That is simply not true, and it's not in the record. But most importantly, he raised the issue of consideration only in post-judgment motions, which I will get to in a minute. But this court has cited the case of Bean v. Bean. It's a 2000 case from the Middle Section Court of Appeals, where the court said courts have routinely held that the failure to make appropriate references to the record and to cite relevant authority in the argument section of the brief as required constitutes a waiver of the issue. Moreover, an issue is waived where it is simply raised without any argument regarding its merits. Coming in here at this late date and saying that Mr. Daniels was available to testify is no evidence. Most recently, Judge Frierson, who's sitting on the panel today, had a case that I've cited in my brief, Taylor v. Taylor, which was entered or issued on March 26th, which states similarly, the Court of Appeals found that where a party's brief contained no citations to the record on appeal and no citations to any legal authority in support of its position, that the deficiencies within the appellate brief are so substantial that it is difficult for us to discern his issues, arguments, and relevant facts. And I think that's what we have here today. The brief filed by the appellant refers under facts to Farm Credit's epic leasing scandal. Well, Farm Credit's not even a party to this case. So there's all kinds. And after having so many delays, not following the dictates of the court to file a brief, I would have expected more than a 2-page brief. However, even if the appellant had filed a proper brief and had cited to the record, the trial court was correct in ordering the summary judgment and not overruling that summary judgment. It's difficult to tell based on the brief exactly what the appellant is arguing. The appellant states that the summary of the argument or the statement of the case is the appeal concerns the order denying plaintiff's motion to set aside. Of course, that's an abuse of standard provision. I note that he did not say that the court improperly issued a summary judgment, but the record is very clear. The motion for summary judgment was properly filed. It was supplemented with depositions. It was supplemented with an affidavit. It was supplemented with certified documents. All of that was in the record. When the hearing occurred, the first hearing, defendant's counsel didn't even show up. That's in the record. We called, Chancellor Cole and I were required to call Mr. Lofton to find out why he wasn't there, and he had a conflict, was what he said. So at this point, the court ordered him to file a response. The response had no citations to the record. He did not submit any additional facts. So, and then on the post-judgment motions that were before the court, the trial court, the court found both that they were procedurally improper and found, and by the way, the first time consideration was raised was in these post-judgment motions. It was not pled as an affirmative defense, which is what is required by Rule 8. It was not pled, but on post-judgment motions, the defendant first raises failure of consideration. The consideration issue is clearly decided in favor of plaintiff in this case. In the statement of facts on page 8 of my brief, I cite the provision of the lease, which clearly says, lessee by execution of this lease also hereby acknowledges that the equipment has been delivered to lessee, that lessee has accepted the same, and that the equipment is in good condition and repair and in full compliance with the terms and provisions of this lease. Only then, as was put forth in the affidavit that was submitted with the motion for summary judgment, was the equipment purchased from the supplier. All of these things that Mr. Lofton talks about Mr. Schindler being a criminal, that's irrelevant to the provisions of this case. There's nothing in the record that reflects that. There was nothing filed in response to the motion for summary judgment. So even if the brief had been properly filed and the brief had followed the rules of appellate procedure, clearly the one issue that's raised on appeal, this issue of consideration, is clearly decided in our favor, and the court found so properly with a properly pled and properly supported motion for summary judgment. The last point that I would make is this is clearly a frivolous appeal. I note that there was no reply brief filed to our brief where we raise affirmatively the frivolous appeal issue. The defendant, in this case, the appellant, has not even bothered to respond to that. And this court, the statute is very clear. Tennessee Code Annotated 27-1-122 says when it appears to any reviewing court that an appeal from any court of record was frivolous or taken solely for delay, the court may, either upon motion of a party or in its own motion, award just damages against the appellant, which may include, but not need be limited to, cost, interest, on the judgment and expenses incurred by the appellee as a result of the appeal. Clearly and respectfully, this is a appeal that is totally devoid of any merit. The only issue raised on appeal is consideration. It was not pled. It could have been pled by subsequent amendment, maybe, but it was never done. So what I have done and what Diversified Financial Services has done is taken this 2-page brief. We've responded to it as best we can, but clearly we believe and we respectfully believe this is a frivolous appeal, and Diversified Financial Services should be awarded its costs and expenses on appeal. Thank you very much.
Does your contract contain an attorney fee provision?
It did, Your Honor. It did, but I did not. It is in the record. I could cite it to you, but when we filed the motion for summary judgment, I did not at that time file an affidavit for my fees in that situation. But it's clear that there is an attorney's fee provision. I could find it, but it does exist, Your Honor.
Okay, well, so you didn't ask for attorney's fees in the trial court, and the only attorney's fees that you're requesting in the appellate court is for frivolous appeal damages. Is that correct?
Yes, Your Honor. That is correct. Thank you.
All right, thank you. All right, we'll hear from the appellant.
Thank you, Your Honor. Just briefly, several things. I think it's an exceptional circumstance, but the appellee's brief has sufficient citations to the record for the court to make a determination on the appellant's argument. And counsel opposite mentioned that we don't have a sufficient showing on the existence of the equipment, and I would admit that, Your Honor. However, the more important aspect is the fact that it was never delivered. There is an admission to that even in the appellee's brief. That's the key issue, I believe. Mr. Daniels it was not a summary judgment hearing for which he was available to testify. It was a hearing on the motion to alter or amend the judgment. I think that's an important point. Judicial notice is under Tennessee Rule of Evidence 201F. It is not something that we have to mire ourselves down into, just the dearth of deadlines that could be examined in this case. And I mean, and there's always, Rule 1 is rarely used. It needs to be used now. Okay, because that we could favor economy over justice, and perhaps it's heading that direction, the state of Tennessee law. But there's again, he got no money, he got no equipment, and there's no kind of half step. All these, I believe that the court will find that all of these cases on point that would lean in favor of the bank, you're going to find some kind of a half step where there's some measure, something that we can call consideration, even if for a very limited time. The wrong equipment, just temporary possession, an ability to do something, an ability to find it, to receive another benefit, some other circumstance that would sort of make up for it. Like I would call that a half step. There's nothing. There's just nothing. Period. The court needs to know that, by way of explanation, Mr. Daniels has started the Chapter 12 process. He has not filed a Chapter 12 bankruptcy proceeding. I know I've learned that we love our farmers. Chapter 12 is a very forgiving, probably the most forgiving chapter under the federal bankruptcy code. But the court needs to be aware that that's where this is heading, and we don't want it. We have to. This appeal is nevertheless important for many reasons, but the court needs to be aware of that when it examines kind of the handling of this. So I thank you. I thank Your Honor. If y'all don't have any questions.
I see none. Council, we appreciate your argument. We will we'll take this matter under advisement and attempt to render an opinion at the earliest possible time. We again thank you for participating with us via Zoom oral argument. Appreciate Mr. Hibner and his staff, Ms. Dempsey, and the AOC technology staff for making this possible. Ms. Angie, if you will recess court to the call of the docket in the morning, please.
This honorable court is